Today we will learn about a famous Supreme Court case that involves high school students and their rights when it comes to publishing articles in school newspapers. The name of that case is Hazelwood versus Kuhlmeier. This case took place in 1983 at Hazelwood East High School in St. Louis, Missouri. The school's newspaper was named The Spectrum, and the principal served as the editor, deciding what could and could not be published in each issue. In one edition in particular, he removed 2 articles he felt were unacceptable, calling them inappropriate, personal, sensitive, and unsuitable for student readers. The first article he disapproved of was about teen pregnancy. The second article was about the effect of divorce on students. The school board agreed with the principal's decision. In response, Kathy Kuhlmeier and several other students who wrote for the Spectrum sued the Hazelwood School District for violating their First Amendment right to freedom of expression. Freedom of expression is included under the First Amendment's Freedom of Speech Clause and basically means you have the right to express your opinion. The United States District Court in St. Louis ruled against the students, stating that the Spectrum was not a public forum, but an integral part of the school's educational functioning, and therefore the First Amendment had not been violated. In other words, the freedom of expression only applies to public newspapers. The students decided to appeal their case to the United States Court of Appeals for the 8th Circuit, which is also located in St. Louis. This court sided with the students. The Hazelwood School District then appealed the case to the United States Supreme Court, the highest court in the country. Each side presented evidence and arguments pleading their case. Hazelwood argued 1. Students' rights are not violated if educators edit school-sponsored publications. 2. School newspapers are not public forums, therefore the First Amendment right to freedom of speech does not apply. And 3. Educators are responsible for guiding and controlling school-sponsored publications because they are a reflection on the school itself. Kuhlmeier's side argued 1. The students' constitutional rights were violated because their articles did not disrupt classwork or infringe on the rights of others. 2. The public school is a public forum, and the First Amendment right to freedom of speech does apply. And 3. An educator's responsibility for guiding student values is not meant to censor student expression or force them to agree with state-approved opinions. Ultimately, the Supreme Court sided with the school district and not with the students. In the written opinion explaining their decision, the court said, "Educators do not offend the First Amendment by exercising editorial control over the style and content of student speech in school-sponsored expressive activities." This means the court did not feel the students' rights to freedom of expression were being violated, because the paper was a school-sponsored activity and the principal was therefore allowed to edit it. They also reasoned, educators are entitled to exercise greater control over student expression to ensure that participants learn whatever lessons the activity is designed to teach, that readers or listeners are not exposed to material that may be inappropriate for their level of maturity, and that the views of the individual speaker are not erroneously attributed to the school. This case set the precedent that school officials, like teachers and principals, are allowed to have a say in school activities like newspapers to ensure that they teach lessons that are appropriate for the age of the students at the school.